Hello? Hi everyone, there we go, much better. Welcome everyone. So I guess judging from the number of people in this room, all of you have lots of questions about the Arpaio case, and that's what we're here to do today, is answer all your questions, and just to give you a little bit of background on the case, talk to you about what happened at the last few hearings, and then to hear from you all. My name is Alessandra, I'm with the ACLU of Arizona. We are part of the team that actually brought this case to court. The ACLU of Arizona became involved with this case in 2008, which seems like an eternity ago. And we are co-counsel with the organization Melendres and with the law firm of Covington and Burling. We're the only organization, though, which is I'm proud to say, is the only organization that's here in Arizona that's representing the third class. So the case, and I know a lot of you will probably have questions about this, the lawsuit that we originally filed, that we became involved in 2008, was a lawsuit seeking to essentially stop these discriminatory practices by the sheriff. 2008 was a really, really terrible year from our community. The sheriff was descending onto predominantly Latino and Yaqui communities, conducting immigration raids and stopping and detaining and arresting people based solely on their immigration status. And so we filed a lawsuit like we typically do as an organization to stop these practices that we believe violate Latinos' constitutional rights. We represent the Latino motorists in Maricopa County. The lawsuit was eventually declared a class action lawsuit. So as attorneys for the plaintiffs, we're representing pretty much every Latino motorist. So if you drive a car and you're Latino, you are a representative of this class. So that's just a little bit of a quick background, because I know, a lot of times when you're listening to the news coverage and reading about this case, that we don't really spend that much time kind of getting into who is doing what. But you'll hear about that today. So in addition to the ACLU, Melendres, and the law firm, the Department of Justice is also part of this case. They are what's called interveners. So what that means is essentially the Department of Justice had a separate lawsuit. It was a similar lawsuit that raised similar issues. And because our lawsuit was resolved and addressed a lot of those similar issues, the Department of Justice intervened, and they are basically part of the team that is ensuring that Arpaio complies with the court orders, which we will get into very shortly. What does all of this mean? So I am actually, we wanted to have this event because we wanted to give you a chance to hear from the individuals, the plaintiffs, the organizational plaintiffs who made this case possible, this lawsuit possible. We could not file this case had it not been for two of the women that are sitting up here, actually, who you'll get to meet. Lydia Guzman, who is a representative of Somos America, who was one of the organizational plaintiffs in this case, and Angeles Maldonado, who is also now is a member of the Community Advisory Board, which was appointed by the court and the judge in this case, but she was also at the time very critical and instrumental in documenting these abuses. And when I say documenting, I mean we needed videos and affidavits and really building trust in the community to encourage people to stand up and bring this case against the sheriff, because we could not have done it without those individuals. And Brenda Munoz Furnish is one of the attorneys in the case. She's a staff attorney for the ACLU of Arizona, and she has been tasked with reading and going through the thousands and thousands and thousands of pages and boxes and all of the documents that we have been reviewing over the past several years related to this case. So that's just a very, very quick overview. I really want to thank you all for being here today. I know it's it's Thursday evening, and I appreciate you taking time from your time with your family to be here today. So I'm going to start off by turning it over to Lydia, who's going to talk a little bit, provide a little bit of background in this case of basically how we got here.
Thank you, Alexander. I think this is on. So first of all, I'm going to go back before the lawsuit was started. And the lawsuit, when it was...
Can I talk a little bit, provide a little bit of background in this case of basically how we got here.
Thank you, Alexander. I think this is on. So first of all, I'm going to go back before the lawsuit was started. And the lawsuit, when it was, I see that folks, can you hear me okay in the back? Okay, great. So the lawsuit was started thanks to a lot of the work of a lot of the organizations. Now, when Somos America was formed, Somos America was really formed a coalition of organizations really for immigration reform. And what we're talking about, a coalition of faith, youth, labor, many different organizations. I believe there were over 30-something organizations. And so everyone, that came to the table to advocate for immigration reform, we started meeting, and we were the same folks that did the march back in 2005, right? And so this is a mega march where we had 250,000 people in the streets. And so we had a really good coalition of lots of volunteers. So at some point, Arpaio was, he was pressured by folks in the community. Pressured because he was starting getting letters from business owners saying, oh, guess what, there's folks that are undocumented, you have to come and round them up, they're standing in the street corners. And there was a lot of controversy over day laborers hanging out over in Pruitt's in front of a furniture store right on Thomas and like 32nd Street. And so as that was heating up, the sheriff's office decided to make it almost into a community confrontation. We started listening to a lot of folks and letters in the community. And it became a political hot button, especially when, right after 9/11, it was a political hot button to go after the immigrant. And so let's recognize the fact that Arpaio, before he's a sheriff, he's a politician. He has to worry about getting re-elected. So this is something that resonated to him, and so he wanted to resonate to his voters. And so what eventually happened is he responded to that by saying, I'm going to do community raids, and I'm going to make our streets safe again. And so to respond to the day laborers, he started doing community raids, these immigration sweeps in the community. Now, as far as I'm concerned, day laborers are hanging out in the street corners, standing, waiting for a contractor or someone to pick them up to offer them a job. But the way that Arpaio was doing this is he was stopping people at night while they were driving. That doesn't address any day laborers, right? And so we started seeing, and that he was stopping folks that were Hispanic, and then that's where everything got started. He started stopping folks that were Hispanic, and so then he set up a hotline. We were so offended by this hotline, a hotline to report, and they were all over his vans and his buses. And then he started with this hotline. If you want to report illegal immigration, call this number, right? And so we said we're going to start our own damn hotline. So we started a hotline called Respeto, right? And so folks could call to see, to report if they were victims of what we, identify as racial profiling. Now, let me just give you a little description of how he would do his raids. He would, in the beginning, Arpaio would announce the raids by bringing the media in. So he would, in the beginning, announce to the media, maybe 2 days in advance, that he's going to do a raid, and he's going to set up in this corner, and he would bring in these big vans and these big, it was like a circus. And there was all kinds of deputies with the posse members, and there was about 200 officers or so that would go out into the community, into like a maybe 3 or 4 square mile area, and he would saturate them, and and he would have them ready to, he would probably release them out about maybe 11 o'clock in the day, ready for the 4 o'clock news. And so what would happen then is, by the time the 4 o'clock or the 5 o'clock news came around, he would have folks displayed there with their zip ties on the floor so he can show the media, look what I did, right? And so, we started documenting some of these cases. And let me tell you, it was difficult at first, and it was heartbreaking, because we would see a lot of the faces, we would see a lot of the families that would come to us. We would set up our own shop, our own operations right next to where they were, so we can see who the folks were, and then also meet the families that would eventually follow some of the patrol cars where they were processing the folks over at their operations center. They would set up a mobile command center, an operations center, and it looked like a circus with lots of media, with lots of folks screaming. And then it came a point where we had pro-Arpaio folks that were chanting and screaming, yelling at the folks that were trying to document, and it just became very volatile. It was heartbreaking. But I'll tell you what, the task of going out and looking for some of the stops and to document it was quite interesting. And I credit a lot of the work with Angeles and other volunteers from Somos America. What we did is, in the beginning, we would actually set up a grid of where we knew the boundaries or the parameters were of these operations, because he would announce it to the media. So we knew exactly where we needed to set up volunteers. And when we would hear on the radio, because we became that elaborate, we started buying scanners, and we would listen to where the stops were so we could dispatch our own volunteers to go out and document. And sometimes our own volunteers fell victims to the abuse of Arpaio's tactics, and they tried to stop us from documenting, from taking pictures. So it became again volatile out in the streets, not only at the Mobile Command Center, but then with us. And before I turn it over, I'll tell you what, this task, even though it changed over the course of some of the years, it finally came to the point where Arpaio stopped announcing to the media, because we were alerting also the public, and the public was, we had less folks being detained as a result of us not only doing advocacy work and education, but also getting information from folks. So Arpaio got keen to that, and I'm gonna stop, I know, but we got keen to that, but from the early stops is where we got the majority of our clientele, so that we can, turn them over not only to the ACLU, but also share this information with the Department of Justice.
So let me just to put it into context. So this is 2008, so it's the height of what sort of the Depression, right? I mean, this is when the economy was struggling. This is when he realized and recognized that by vilifying Latinos and Mexicans in the press, it would score him political points. And so much of that information that was collected is what ultimately became the evidence that we needed to bring the case forward. I also want to say, just also to put it into context, this was 2008, 2 years before the passage of 1070. So these practices became the so-called model that the legislature was purporting to replicate statewide with the passage of 1070. They used Arpaio as the model and as the sort of the impetus to pass 1070.
Correct. And I just also want to add that Arpaio then had a weapon that he no longer has. An agreement that he had then called 287G, in which the immigration allowed him to enforce immigration laws, of course, but he used it. That's why it was revoked.
And the other sort of item that sort of came forward, and it's just the reality that came forward during the trial, is the fact that when you are stopping Latinos with the stated purpose to check their immigration status, in a county where 30% of the Latinos, in a county where the majority of Latinos are U.S. citizens, what ends up happening, and what did end up happening, is that a lot of these cases that Lydia and now Alkin were documenting were stops of U.S. citizens, of legal permanent residents, of people who were here lawfully, who were being stopped and subjected to these practices simply because of their national origin in the city.
And it was bound to happen. When you release 200 deputies out in the 3 square mile, you expect them to come back empty-handed. When they're told to, this is an operation, and they did come back empty-handed, and that's why, we have those claims.
So fast forward, we'll turn it over now to Angeles. She's going to talk to you a little bit about her role as the member of the Community Advisory Board. So, we got a decision there were several decisions. There was a big decision in 2012. Essentially, it was a decision the first time that the sheriff had ever been found to be violating the constitutional rights of Latinos. That important decision came down in 2012. And as part of that decision, the judge created and issued a series of remedies of reforms to begin reforming the MCSO and to stop these discriminatory practices. And that's where the creation of the Community Advisory Board came in, where there are 3 individuals that have been assigned to the board, Angeles is one of them, that are essentially the liaison between the court and the community. So I'll turn it over to Angeles now.
Thank you so much for the opportunity to be here to talk with you all. I know that many of us would rather be home having dinner with our families, but I thank you for ensuring that discrimination and racial profiling doesn't continue here in Arizona by staying informed and engaged. I want to share with you a little bit about my perspective as part of the Community Advisory Board and also a member of this community, and also as a scholar activist. But before I do that, I want to tell you a little bit about myself and my background in order to contextualize my experiences. My name is Dr. Angeles Maldonado. I am from Mexico. I was born in Salvatierra, Guanajuato, and I came here when I was 8 years old because my parents wanted to provide us with better educational opportunities. And so in 2002, I graduated from Arizona State University with a bachelor's in justice studies and a minor in philosophy. And then I got my master's in public administration and most recently got my PhD in educational leadership and policy studies. But despite all of my education and my degrees and my research, I feel that the place that influenced me the most and where I have learned the most was in spaces of fear and resistance here in the community, in places like this one where community members organized and we learned a lot of different things about what it means to live and belong in Arizona. I learned about my identity and I learned about what it means to be an American. And so my research focuses on looking at the hidden curriculum in social movements. And I feel that we are still learning today what that means. You know, we are learning today what it means to belong. In 2005, we were exposed to a growing nativist anti-immigrant sentiment. And as mentioned, Arpaio paid attention to that and saw that he could become very popular by being anti-immigrant himself. And he has effectively became a symbol of injustice and a symbol of racism and legitimized racism here in Arizona. And we, later in 2007 and in 2008, we learned that driving while brown could end up in deportation. We learned that our families could become separated. But we also learned what resistance can look like. We learned how to fight back. And today here, and with cases such as Melendres, we are learning and defining what it means to be on the right side of history. So the journey has been a long one. And I was thinking the other day that it has already been 3 years that I've been a part of this community advisory board, and 9 years since I have been organizing around Arpaio. And I say around and not against because I believe that our real problem is systemic racism and white supremacy rather than Arpaio himself. So what does it mean for me to sit in a courtroom surrounded by familiar faces? I feel a lot of different emotions. I feel excitement, and I feel like we have been climbing this big mountain, and a lot of us came through it with many different tactics. Some people told us not to climb the mountain to begin with. I see Sal over there. And some people, use different tactics. But despite the different ways that we took about this, I think the beautiful thing is that we were all united with the same goal of getting to the top. And for us and for many members in this community, getting to the top still means to see Arpaio in jail and to just see the MCSO held accountable. And so even though he has now been found guilty of civil contempt and there's not much that can be done with regards to criminal charges, I do think that there's still more work to be done, and I think it's up to all of us to continue to press forward. In the hearing on May 31st, we heard the judge say that the U.S. attorney actually does have the power to bring charges against Sheriff Arpaio, and so the Community Advisory Board has written a letter asking them to do so, and then also asking for a meeting. And so what I want to do today is just continue to encourage you to stay engaged. No social change will ever come about without our continued presence. We also have a survey that is in the back in case you want to write any comments about your experience with the with the sheriff. And we're here to be a resource for the community and to be the eyes and ears for the monitoring team. So if there's anything that we can do, please let us know.
Thank you, Brenda. So I'm going to turn it over to Brenda now. So can you, Brenda, just kind of give us a little bit of a summary of what took place on May 21st, this hearing that Melendres was referring to?
Yeah, so I want to back up a little bit before that and just do a brief overview of how we actually got here in the legal case. So, as we already talked about, this case started about 8 years ago. It was filed in 2008. And then in 2011, Judge Snow issued a preliminary injunction. And with this preliminary injunction, he ordered Arpaio and MCSO to immediately stop engaging in these immigration stops. So then there was approximately 2 weeks of a trial in 2012. And then in 2013, the judge issued an order. And the judge agreed with us. He found that MCSO, they were racial profiling. Profiling people. And he then issued another order shortly thereafter, and he required MCSO to undergo a lot of agency-wide changes. And some examples of these changes include requiring all MCSO personnel to undergo and to attend constitutional trainings. They also had to start recording data on traffic stops. And they also had to start issuing traffic receipts to people that they stopped, regardless of whether they received a citation or not. Deputies also had to start wearing body-worn cameras. That's something that was really good that has been implemented. And they also, Judge Snow also appointed a monitor to kind of oversee all of these agency-wide changes and to really be the watcher on this. So that was in 2013. Now let's fast forward to 2015 and to the current contempt proceedings. Now, as we talked about earlier, the current proceedings before us are civil contempt proceedings. These are different from criminal contempt proceedings. This means that Judge Snow cannot order Joe Arpaio to go to jail. That has to be done in criminal contempt proceedings. Now, what the judge can do is he can recommend to the U.S. Attorney's Office to start criminal contempt proceedings. And while we don't know if Judge Snow for sure is going to make that recommendation, we are hopeful that this recommendation will be made. So there are 3 things at issue in these current contempt proceedings. One, we, the plaintiffs, allege that Joe Arpaio and others in MCSO violated the preliminary injunction from 2011 and authorized immigration stops to continue after that 2011 order. 2, we also allege that Arpaio and others concealed important evidence in the case. And then 3, we alleged that Joe Arpaio and others in MCSO actively ignored court orders to finally gather this additional evidence in the case. So those are the three things at issue in the current proceedings. So then, throughout 2015, there was approximately 3 weeks of hearings, and Judge Snow heard all of our evidence. And then he finally issued his order on May 13th, 2016, just last month. And in that order, Judge Snow did find Joe Arpaio and others in MCSO to be in civil contempt of court. He did find that they intentionally violated court orders. So, in his order, he also set a hearing, which was scheduled for May 31st, 2016. That was just last week. And at this hearing, the parties discussed what remedies should be imposed for these contempt findings. What does Arpaio and MCSO have to do because they intentionally violated the court's orders? So the judge brought the parties in, and all the parties discussed what they thought should be imposed. And we, the plaintiffs, we asked for a number of things. One, we asked that the victims of the preliminary injunction violations be compensated, that they receive a money settlement. Two, we asked to enlarge the monitor's duties and authorities, mainly to oversee more compliance with the 2013 order, and to really oversee MCSO's internal investigations process. We also asked for stricter deadlines for full compliance with the 2013 order, and we asked for more reforms in MCSO's internal policies. So that's what we asked for, and that's what was discussed last week in court. So now the parties we have to submit additional documents to the judge, and then there's another hearing that's scheduled for next Friday. And then hopefully, then Judge Snow will issue his final order about the remedies for these contempt violations. And that's where we are today.
So Brenda, because I'm sure a lot of people in the audience are curious, so can you tell us what the difference is between civil and criminal contempt?
Yeah, so as I touched on it a little bit earlier, one of the big differences is that about the remedies of contempt. So in criminal contempt, in civil contempt, the judge really can't order anybody to go to jail. That would have to be done in a criminal contempt proceedings. And those proceedings would have to be initiated by the U.S. Attorney's Office. Judge Snow, in these current contempt proceedings, can't do that. But the difference between civil contempt and criminal contempt really is, like, what's the goal of these different types of proceedings? In civil contempt proceedings, the goal really is to vindicate the interests of the people who, the victims of the contempt. And so that's why we're asking for some compensation, some monetary compensation for the victims, and to see further compliance with the judge's orders. So that's the main difference.
So before we turn it over to the audience members, I just want to introduce 3 people, actually. I just wanted to introduce our senior counsel, Dan Pacoda, who has been involved in this case from the very, very beginning, and who was instrumental really in pulling together the ACLU, the team essentially that brought this case forward. So we also wouldn't have been here had it not been for Dan. And then I also just wanted to introduce 2 of our board members, Marie Provan, Rivko Knox, and do we have another board member, ACLU board member? Oh, and then Leticia there. Okay, so all of you raise your hands. Raise your hands, instrumental because they approved the budget that helped pay for this. So anyway, so let's turn it over. We really wanted to spend more time just hearing from you all and responding to any questions that you all may have. Yes, so.
How do sentences in either a civil case or a criminal case affect Arpaio as an elected official? what capacities would it change or prohibit?
Who wants to take that?
Sure. Well, not necessarily anything. As we know, there are people who are convicted felons who get elected to various offices. In Chicago, it's a prerequisite, of course. It's very hard for this court or any court to do something to an elected official as opposed to all of the other employees at the MCA, so there are much greater constraints. But the goal of the criminal contempt, as you said, is to punish the wrongdoer. So I'm assuming that would have a significant impact on the political prospects of this fellow if he's convicted. But that's a little down the line. But it's not automatic, like the night the day that he would be fired. Now, his chief executive, this fellow Sheridan, who runs the jails day-to-day, should, if convicted of criminal contempt, be under various state laws fired. And he really is the person who runs it day-to-day.
I'd like to add also something to that. As far as the operation wise, during this last court hearing, the judge did mention something about receivership, about part of the internal affairs investigation piece, because the judge really wasn't too happy with the way that the sheriff's office were investigating themselves and then clearing themselves from any sort of wrongdoing. And so, as far as that, the judge said, I may not be able to fire. The judge said, he might want to take hold of that piece, some sort of receivership of that, and also the ability to fire people. He may not have the ability to fire an elected official, but the other folks are sworn officers, and under the county merit system, they can be fired.
And I do want to clarify that we as plaintiffs, we asked the monitor to take over those internal investigations.
Financial compensation would be paid by Joe and not by the taxpayers?
That's correct.
Well.
Well,
And I think that was a big factor in the judge's decision. He said it repeatedly through the various trials, where he recognizes that if it's just the taxpayers that are paying, there is no sort of personal consequence for Joe itself. And I think what makes this case unique, there are these types of reforms that are happening across the country, for example. But what makes this one as unique is we didn't come to an agreed upon. It's not like the ACLU and MCSO came to an agreed upon consent decree. What happened here was the judge had to issue the ruling, and so we have an elected official, a sheriff, who is recalcitrant, who's been fighting us tooth and nail from the very, very beginning. There are other departments now that are working with court-appointed monitors where it's obviously not as contentious because the parties came together in the beginning and realized that it's in the interest of the community to just work together. And there's none of that sort of happening here.
And the judge did say he wanted to make sure that there was that Arpaio had teeth in this, or what was it? Skin in this. Only because the judge is fully aware that Arpaio could raise a lot of money like this, and so I think that the phrase that he said, he didn't want this to come out of Friends of Joe.
Yeah.
So.
I didn't quite hear about the cameras. Did the court require that the officers wear body cameras, and are they doing so, and will the videos be available for the public to see?
so as part of the 2013 court order, they were required, MCSO was required to, at first the order required them to install cameras on their cars, on their vehicles. And then the order was amended so that it says that they had to wear body-worn cameras. And all the deputies had to turn them on right at the beginning of a traffic stop. Most of the districts in MCSO have these body cameras and they're up and running. I believe there is one district that isn't fully operational at this time, but I would have to check on that.
And yes, they are subject to review by the
Yes.
public. The videos
Public
are
records.
public records, so they are, any member of the public can ask for those videos. And I think the irony is that, once they do come into compliance, I mean, these are really strong policies because it's part of the litigation. We've been, we're involved in crafting these policies, and they're some of the strongest body-worn kind of camera policies. And we're trying to use some of these model policies and trying to leverage the decisions in the Arpaio case to convince other police departments to also update their policies. Because, the irony is that we do have MCSO deputies that are wearing body cams, but we don't have all of the City of Phoenix, for example, officers wearing body cams.
Yeah, what is going to happen with all the items confiscated by the deputies through the years? Are you going to trace back the names of these persons, for example, when it's a private license or a document or a matricula consular? What is going to happen with the medallitas or?
Right. Well, I believe that that was part of, and I'll probably yield this to the attorney, but I believe that was part of the one of the requests that the ACLU said that asked perhaps reinvestigating some of these, because these IDs belong to someone who was stopped, whether they were stopped maybe by one officer at when it was initially thought, or they discovered that there were several officers that conducted these stops. Finding the owners is going to be part of, I believe, of the investigation, and a lot of that is going to have to be reopened.
Can you explain, maybe, or you or Brenda, explain what these items are that Carmen's referring to?
So in the course of MCSO's traffic stops and stopping Latino drivers for the sole purpose of investigating their immigration status, it was discovered that they confiscated a lot of personal items, IDs, license plates, passports, what have you. And they kept them, and they never returned them. And it was discovered that MCSO was pretty much hoarding all of these items and really didn't do anything with them. They didn't log them. They didn't have any system of record keeping. And they were just sitting there in MCSO offices. So this was actually something that came up during the trial. And it was very surprising when this information came up. So yes, that is going to be part of the investigations to try to trace back where these IDs and everything that was confiscated during these stops were.
Can you talk a little bit about sort of your role on the CAB in terms of sort of the outreach and maybe elaborate a little bit on what you all will be doing over the next few months?
Sure. So one of the things that we are required to do is we're required to hold 3 community forums throughout the year, and also to help the monitor team just give feedback back, whatever we hear in the community, to tell the monitor about what's going on in the community, what we're hearing, and then also if we know anything from the monitoring team to report that back. One of the things that I didn't mention earlier is that currently the MCSO is only in compliance 39% in compliance. There's 87 mandated reforms, and they're currently only at 39% compliance. So I think that's another item that we're looking to push on and to see why that hasn't improved. And so as Brenda mentioned, some of the remedies that they're asking. And I think the judge, one of the things that I found that I liked hearing at the hearing was that there could be the potential for other more repressive remedies if they don't get in compliance, right? Mm-hmm. Okay. Yeah, there you go. Yes.
Some of the tactics that he has used in the past have included investigating the judge's wife, the board of supervisors, various other people, anybody who basically crosses him. That was his ploy. Has that been addressed? Is that something that he cannot do anymore? And also the destruction of records. That was another thing that he the office was ordered to
Right.
maintain records and maybe destroy them.
So do you want to talk about that, Brenda? Records and abuse of
Yeah,
power.
so regarding the records, that was one of the main issues for the current contempt proceedings. And the judge did find Arpaio and other higher-ups within MCSO to have done that in violation of court orders. So that's something that will definitely be addressed, hopefully when the judge issues his next order about remedies.
How about the abuse of power piece?
Yes, and as far as you know, the abuse of power when Arpaio investigates the judge, for example, the judge specifically said, you know, even though the judge cannot, you know, find him guilty for, you know, criminal whatever, but in court, you know, I don't have a problem with you investigating me. What I have a problem is the fact that you lied to me when I asked you about it in court. Okay, so that in itself is a violation. Now, has he done it in the past? He's done it to several people. Terry Goddard, he's done it to county supervisors, he's done it to all of his critics, and that was part of what the Department of Justice was looking into when they filed their lawsuit, and they came to an agreement, and in their, what's the term? When they came to the agreement in court, when they settled, that's one of the things that Arpaio said, I'm not going to investigate, you know, any more of my political critics anymore.
Right, that was the subject of the separate Department of Justice lawsuit. They were looking at the racial profiling, they were looking at some language access issues like access to the courts, and they were also looking at these investigations, whether or not they would initiate sort of proceedings against him, and they decided not to as part of the settlement.
But a lot of the folks that were investigated or falsely accused of something, let's keep in mind that they sued, they pushed back, and guess what? They won.
Just two things. As Lydia said, Sheriff Arpaio lied to the judge. Just quickly, how is that not perjury?
Exactly.
Second is, if I understood the monitor correctly in a meeting a couple of months ago, he suggested that there was the possibility that he and his team might be granted greater enforcement powers with regard to this case. And I didn't entirely understand what that meant. What would that look like if that's true?
Yeah. We believe it is perjury, and we, in our submission of recommended steps, next steps by the court said it should refer to the U.S. Attorney to investigate the possibility of criminal contempt and perjury. I think we had another federal crime in there, but I forget at the moment, that we believe was warranted by the facts. The additional powers, right now the monitor, which is a very important factor in the case, there's a team of 10 people on the monitoring staff. None of them full-time, but significant amounts of time and taxpayer dollars.
Can you talk about who these folks are?
Yeah, the monitor is Bob Borshaw, who has, and the majority of the folks on the team are folks who have gone up through the ranks of various law enforcement agencies. They were very much vetted by us. We nominated them along with a couple of others. Each side had to nominate to put up the nominations to the court before the selection, and we found that they were doing a lot of diligence, that they had done a good job in other cities, and they probably are still involved in 2 or 3 other cities, including Oakland, where there is basically a receivership, and others. So yeah, it's mostly law enforcement. There are a number of academics because there's statistical issues involved. There's a 5-star ex-general, or you're always a general. And they've done a very good, decent job. not easy, as they say, they've never seen, and they've been involved in many, both in terms of their own careers and in the role of monitors, in many agencies. They've never seen anything run as badly, incompetently, before you can get to intent as this one. Just literally incompetently. That's why it's always hard to parse out whether something is evil or stupid. But it doesn't matter in the end in terms of, yes, combination for sure. In any event, the monitor reports to the court. The monitor generally, at the moment, does not have the power to order the sheriff to do A, B, C, or D, or to stop doing A, B, C, or D. As Brenda was talking about, what this would do would give, at least in a limited area, but one that is a very important first step in terms of limited receivership, allow the monitor to have the final word in a particular area of MCSO operations, specifically these internal administrative investigations, a final word on what guilt or innocence, so to speak, of the person involved. And there's no further appeal other than to state courts, but nothing within the agency. The court found that these internal investigations were literally shams. They were part of a cover-up of the wrongdoing, and they were fixed in a way that no one would be found guilty. I think one person was found guilty and got a minor discipline. So there will be a great hue and cry when the court does, and the court will, give even this limited power to the monitor to directly intervene and order, be the final say in a certain limited area, but in running of the MCSO.
In terms of the internal investigations,
Yeah.
right? I think somebody had another question. No? Any other? Yes?
Can Arpaio appeal the decision that will be coming down on June 17th?
Well, it's very limited because they developed a strategy of actually acknowledging that they were involved in civil contempt as a way a number of months back to try to get out from one of the hearings. The judge said, fine, I'll take that acceptance, and we will still have the hearings. Because the key finding by the court is that they were intentional violations, which is a prerequisite for even a referral for criminal contempt. So there's very limited leeway for the sheriff to appeal. I wouldn't be surprised if they try it on some procedural grounds. They have not been shy about doing so. They have not succeeded in any appeal so far in this case over the last 5 years, but I wouldn't be surprised. They stated, what was the opening line of their submission on the court's findings? Quote, the sheriff was devastated by these findings. But we still remain interested in working things out because they're trying to avoid the criminal referral, which we think is quite probable and which we recommended.
Dan, if you want to go ahead and move over here, that would be good. Sorry, we didn't know he was going to attend. So, le estamos pidiendo a Dan que se mueva para allá.
It's a much nicer panel that way. That's it, thank you.
I saw somebody else with a hand raised.
Oh, you have to transfer. Oh, that's I thought it was for me.
Can one of you sort of, and feel free to sort of weigh in about what the harm piece, because I think a lot of times we kind of forget about the real victims in this case. We recently, so over a period of approximately 17 months after the judge had ruled that Arpaio cannot stop and detain and arrest people based solely on their immigration status, he continued to do that, which means there were hundreds and hundreds of people who ended up in detention, immigration detention, after the judge had ruled that practice was unconstitutional and it violated their rights. And we recently have been trying to track those people down. And you know, our legal director, our former legal director, finally got in touch with one of the folks that we've been trying to track down, and he said to us, "You found me," and he was in the Eloy Detention Center. And he had been there for the past year? Over a year. And so this is really, these are the real victims, and I think that we kind of lose sight of that because, so does anybody, do you want to talk about that? Sure.
So the injunction came down in December of 2011, when, before we went to trial. And when the judge says you cannot stop people to ask them, solely because you suspect that someone's undocumented, and Arpaio continued to do that, this not only was related to some of the folks that were citizens that were here legally, but when someone was stopped and they happened to be undocumented, but because they were stopped because of the fact that they were suspected of being undocumented, those are also some of the folks that we're going to be looking for, like this person who's in Eloy. Now, some of the folks, the damages are horrible. Families were separated. People had to incur legal fees and then you have the cost, the human cost to this. I don't know how you would put a price on a human cost to this, because when you have families that are torn apart, children that are left behind crying, Angeles and I have to deal with a lot, and Sal Reza and many folks here, Margarito and some of the folks from Somos America, we had to deal with a lot of the families that were left behind. The folks that didn't necessarily make it to the front page of the news, or the ones that Arpaio was talking about in his press releases. We're talking about the kids that were left behind that wondered, why didn't mom come home last night? Why didn't my dad, get stopped and then the men took him away? That's the human cost. There's psychological damage, there's economic damage. When the breadwinner gets torn away, people lose their homes, people lose their stability, people get uprooted from their families. So it's not just the person affected that gets stopped, it's also the trauma, the psychological, the human trauma.
I would say that we are still very much in the process of looking for folks. I mean,
yes.
Even the county now has agreed to pay this firm that is going to be running the compensation program $200,000 for the search, because we will be putting, and they will be putting materials in media in other countries as well as the U.S. Because we're very much looking, and it's not going to be easy. People happen to know folks who were stopped by the sheriff's office from December 2011 on. It may well turn out that it was a valid stop, because you can be stopped for a state crime. But we certainly are interested in getting all names, and any help is appreciated. But it's going to be a real chore, and we're committed to having funds available. So if at any point in the next year or so we can find people, they will be have compensation to make them whole. As said, we have asked that $300,000 of that be out of the sheriff's own pocket, and we'll see. I don't know if the judge will do it or not. He may feel that the civil contempt would give them a ground for appeal, because you're not supposed to quote unquote punish, but I consider that mild given the actions taken by this guy.
Can I also just add that from the beginning, when we initially filed this case, it wasn't about damages and seeking damages. We initially filed to stop these discriminatory practices, and it wasn't about getting him, putting him behind bars. It was about reforming the department. It has turned into both of those because of his dishonesty, bad behavior. Like willful, ignorance. Willful ignoring of the order. Marie.
Yeah, you can probably hear me from here. I just want to know how much is going on the part of the Phoenix Police and perhaps the Tucson Police and some of these other departments that are not involved in this litigation. Does anybody have any estimate about that?
Sure, that's actually a really good question.
It is.
Yeah,
it is.
It's a really good question, because when we sit down with all of the local police departments to say, well, here's the Arpaio decision saying that you can't stop people based solely on immigration status, they say, oh no, we're not like Arpaio. And the reality is that they are, and they are running the risk of violating people's civil rights as well. And I think the bigger picture here again is that we still, 1070 is still on the books, right? We have tried in a separate lawsuit to strike down that remaining provision of 1070, And to your question, Marie, you know, the city of Tucson has been one of the worst offenders because they are routinely contacting Border Patrol. They are stopping people for minor traffic stops and then waiting for Border Patrol to get there and then referring people to Border Patrol and prolonging detentions solely to check people's immigration status. So it's the very same practice that was declared, that was prohibited and declared unconstitutional in the Arpaio litigation. And so that's what we're, you know, that's the reality that we're dealing with, right? There's a new chief in Tucson, so we're hoping that we could, we're working through these local departments to pass some policies at the local level that limit enforcement of immigration, and particularly for vulnerable populations. And with the city of Phoenix, you know, we're going to be asking all of you, when there's a new chief, to also pressure the city of Phoenix, because the reality is the city of Phoenix is the highest, I mean, they have very large numbers of deputies out on the streets. It's a much larger department. And, you know, they are the ones that are interacting with most of us. And so that's going to be part of our sort of strategy moving forward.
Yeah, I just want to also add that I think the damage that Arpaio has done is not just to those individual families, but because he is constantly on the media, I think that he has influenced the rhetoric that basically has defined what Arizona is. And so there's different states that have looked to this state to see the practices that he did, how he enforced local immigration, and also the other police departments that are also that have also been watching. So I think it's super important that we decide how this narrative ends, because we'll be sending a strong message about, you know, how we respond to this type of practices.
Mm-hmm. Right, and I had the opportunity, was invited to a couple of years back to visit Utah and talk about what happened here, because they didn't want, you know, to happen to that community in Salt Lake City to happen here. And so it was quite interesting to share that experience. And I also want to give kudos to the ACLU for taking the court's order and taking it to the different police departments. And for example, I heard that in Mesa, they were quite receptive, and they, you know, they look at the court's order and say, well, you know, in order for us not to be the next Arpaio, let's, you know, look at some of these changes so that maybe we can implement some of this so that we can protect ourselves, which I think is a good thing. And thank you for, you know, for doing that, ACLU.
There have been some positive changes, and Mesa is one of them. Tucson is also one of them, but they are not complying with their own policies. And South Tucson, those are the three police departments that have made changes to their policies. And the one in Tucson actually is a really good one, because in their policy they stated that they're not going to allow school resource officers to question kids about their immigration status, which happens in our schools. And so that's a whole other forum topic. Do folks have any other questions? Yes?
A lot of these people were physically abused. Broken fingers, hands, arms, broken jaws, smashed faces. Are there going to be any remedies for the physical abuse of these people?
Yeah, so the people who were detained, who were stopped and detained after the 2011 preliminary injunction, our proposal is to have a baseline for compensation, and then an additional amount of compensation depending on what that individual had to go through, whether it be, you know, prolonged detention that was very, very long, whether it be that they had their possessions taken and never returned, or if they experienced some other sort of trauma.
I know it might be difficult to do, but is there any way that individuals can be held responsible for individual acts, and I mean criminally?
Theoretically, it's going to be difficult, but yes, theoretically, sure. You need a prosecutor who's going to take the case.
So what exactly is the likelihood that this will go to the federal level and be taken to the Attorney General of the U.S.? What is the likelihood?
Yeah, so it would be the U.S. Attorney's Office who would have to initiate criminal contempt charges.
What is the likelihood?
On a scale of 1 to 10, Brenda, we're putting you on the spot.
Well, you know, we can't really say for sure, if Judge Snow is going to make that recommendation. But we think that it's really likely that he
Like a 7, maybe?
You know, based on language that the judge used in both his order and at the hearing last week, we think a recommendation is going to be very likely. But you know, I do have to say that even if Judge Snow makes that recommendation, that doesn't mean that the U.S. Attorney's Office has to initiate those criminal contempt charges. It really is all up to the U.S. Attorney. And that's why this letter that the CAB is putting together, that they want to submit to the U.S. Attorney's Office, is really important.
I think we had a question over here. Yep.
In 2003, Arizona DPS had a profiling issue that resulted. Did the ACLU use that as a reference in this?
Yeah, Eleanor Eisberg was the head of ACLU then, and I worked on that case as a cooperating attorney. You're not yet on staff. So there was a consent agreement in that case, a settlement agreement, that was really quite good given our limited leverage. And for sure, and it included record keeping and a community board. It was a 5-year existence of that decree, which is over now, and I'm sure they're not doing the record keeping. But yeah, that was certainly an input we used in formulating the relief in this case.
So actually, we just filed a records request also to the Department of Public Safety over those records. I was on a panel with Frank Milstead, who is the chief DPS, and I said, Frank, are you guys still collecting data? And he said, we sure are. And I said, well, can I have it? And he said, well, send us a records request. And so, I mean, I think to your point that what happens, unfortunately, with a lot of these departments is that we believe, the ACLU believes that it's in the best interest of police departments to collect stop data and to collect data on the race and ethnicity of the people that are stopped, because that's really the only way that you can determine whether or not a problem exists.
They did for 3 years.
They did, right. So they did, and so they claim that they're still collecting that information. And so that's why we filed the records request. And so a lot of these departments, what happens is when they are the subject of a court order and they're under some sort of a settlement period, they comply, and they spend all these resources to reform their entire systems, and then once that litigation ends, also those taxes end. So it's really about kind of changing the culture. There's a lot of good conversation happening now nationwide as part of the president's kind of 21st century community policing model that are recommending data collection, that are recommending a lot of the reforms that are coming out of this case. But, we have to convince these departments to do these things voluntarily, because when it's in the context of litigation, it's very contentious, and they're not happy about it.
Gentleman in the back.
Yes. Yes.
Excuse me. Back in 2011, the state legislature passed the bill. Back in 2011, the state legislature passed the bill establishing that undocumented immigrants are not entitled to receiving punitive damages. As far as I understand, it was passed, signed by Governor Brewer. I don't know if that's still a valid law. Do you know if that's still valid? Do you know if that might have an impact on the possibility of any undocumented immigrant either living outside the United States or here in the country, that it's entitled to compensation in this case? Do you know if that state law, if it's still valid, might affect that possibility of having them compensated?
No, we would not be getting, quote, punitive damages as a result of this compensation. We would be getting actual damages to make the person whole, that we can prove, whether it's physical or just for a certain amount of time that they should not have been detained and so forth. So it won't come up in this context. Yeah, the law is still on the books, very much so.
There's another question.
Hi, my question is this only for the people that were stopped when they were driving, or the people that were arrested at work too?
That's different.
Both. Judge Snow has been made clear that his definition of the class, which has read, as I wrote it in 2008, which is every Latino passenger or driver in a vehicle stopped by MCSO. That's the class definition. And I have to admit that I was thinking about people who were stopped in their own cars. Now, the judge has made it clear that he considers, because they technically fit the class definition, people who are picked up in these workplace raids, which are generally not in cars, although we did have a case at the ACLU where it was in a car, and one of the cases just outside of a work site as they were on their way in. But he said if they are stopped wrongfully by the sheriffs and then taken in a sheriff's car, which they generally are, of one type or another, he considers that to be a member of the class. So at the moment they will be included in the people who could get the damages, and that's a very good point. From a workside raid situation, which is the subject of another Puente case that ACLU and others are doing. So yes.
And the judge actually did reiterate that class expansion at the hearing last week.
Go ahead, Sal.
Yeah, what's going to happen with the Yankees, the Honolulu, the Cocopa, that I personally saw getting stopped? They're not Latinos according to the past. Are they going to be included or not? Because they're also victims. And many of them were stopped. I know in Guadalupe, a lot of Yankees were stopped. And I saw personally to Honolulu and Cocopa getting stopped when we were monitoring them. So what's going to happen to them?
Yeah, it's going to be hard to fit within this structure. You know, at the time when we were writing the complaint, we did not have any examples, and I'm sure it's because I was ignorant than others of the community here, and I apologize, but it was only written in terms of Latinos. So it's always hard to get relief that goes beyond the class definition. In this particular case, not in follow-up.
I have a kind of two-part question. The first one is to try to find out, or if you have an idea, why there has been low turnout at these meetings with the monitor team in the different sections that they set up the meetings. And the second part is for an average Maricopa County resident, or the question would be, what are your recommendations for an average Maricopa County resident to get fully involved in the process in order for the MCSO to come into full compliance, and to also assure that the results of the Melendres lawsuit are adequately fulfilled? So that's my two parts.
Yeah, well, first and foremost, about I'll address your second question. I think it really is important to attend all of these community meetings, to attend the monitor meetings. At these meetings, you can talk to the monitor, you can give your input, and people from MCSO do attend these monitors meetings. So that is your opportunity to actually address, people actually in MCSO. So yes, please attend these meetings. It really is very important. And I would also recommend, attending our CAB meetings and paying attention to everything that the CAB's doing. For instance, this letter that the CAB has written and they want to submit to the U.S. Attorney's Office. That is really important.
In the last monitors meeting, one of the things that Chief Warshaw said that he would like to see, of course, more community participation, but he would like to, at some point, see the community ask questions directly to the sheriff's office, because that's what it's about, holding the sheriff's office accountable. And he would like to see those questions directed to the sheriff's staff that's there. That way they can answer questions or be held responsible and accountable.
Yeah, I think one of the reasons for the low attendance, I think, has to do with the location. Some of these meetings are held in really far out places because they're required to be held in the different districts. But the monitor has received a lot of feedback from the CAB about this, and I know that from our last discussions, they are going to try to do them more centrally located. And then the other thing that was discussed is, instead of us holding meetings, for us to actually go into already existing functions and participate or be available to you guys so that we can go into the community as opposed to just always expecting the community to come to us.
And the meetings are, it's what, 7 districts? So there's a meeting, there's supposed to be a meeting every 3 months in one of the districts, in one of each of these districts, and some of them, I mean, there was, a meeting in Buckeye, and I think it was like probably Lydia and the monitor team that was there.
That was it.
And I think that is a problem, and so that's one of the recommendations, that we have them in centralized locations that are more accessible to people. Yes, sir.
Thanks. Is the CAB letter to the U.S. Attorney's Office available somewhere on the internet, and are you soliciting public support for that letter?
Yeah, we just wrote it, so it's a draft. I did bring some copies, and I am going to put it up online, and we are soliciting support for anybody who wants to sign on to it. So.
There's also a website that's called changingmcso.org, and so on there we post all of the meetings, right?
We have a Facebook page also.
We're posting both the CAB meetings, the monitor meetings, all of the filings in the case. So if you go to that changingmcso.org.
Yeah, we have a Twitter also.
Twitter.
Yeah.
Oh, and there's a handout too in the back.
Yeah.
That has the website
And all the contact information.
and all the contact information for the CAB members as well. And to contact.
Oh, that one.
Oh. Okay. Yes.
Yep. There are victims in the field, whether it's for MCSO or for any other agency. Who can they contact? I mean, they're incarcerated, besides a private attorney, what can they do?
They can contact, there's several organizations that are taking this information, organizations like Dona Tierra, like Puente, organizations like, I'm now at Chicanos por la Causa also taking in a lot of that. There's the CAB as well, the ACLU also. So there's several organizations, and believe it or not, we share information, we talk to each other. So
yeah, we are accepting complaints from all these agencies, but for the purposes of this litigation and for complaints to the monitor, it has to be obviously MCSO related.
Mm-hmm.
Yeah, and I think in our handout that we're handing out tonight, it does have the monitor's information, where if somebody is stopped by MCSO, they can.
You can email the monitor directly.
Yes, then they can contact the monitor directly, in addition to contacting us at the ACLU.
There's a phone, there's an email, and there's US mail.
So can one of you talk a little bit, I think maybe Brenda, you alluded to this during your initial comments. You said, because I think a lot of times, we lose sight of this because the reality is he's only complied with, 38 out of 87 different measures, which is not a great record. But there are some things, like you mentioned, this traffic tickets. What does this mean to the average person who may be stopped by an MCSO deputy?
Yeah, so while, these overarching changes within MCSO as an agency, it is slow going. But we hope to change that soon with these new remedies that the judge will issue. So some of the changes that have already been implemented, one, I think we've already discussed the body-worn cameras. Those have been implemented in most of the districts in MCSO. And then traffic stop deputies are to keep track of all of the traffic stop data, meaning that they have to keep track of the time of the stop, the reason for the stop, the name, the age, the perceived race of the person who they stop. They have to keep track of all of this. And their supervisors are supposed to review all of these records every so often to keep track of any sort of bad or questionable behavior that might pop up during these traffic stops. Now, MCSO deputies, they also have to now issue receipts to people who are stopped in these traffic stops. And these receipts will detail some of this information that I've already said, but it has to give like the deputies information, the reason for the stop and so on, so that if somebody stopped, they have a record of it, and they know exactly why they were stopped and who they were stopped by. So that if something maybe bad or questionable does happen, they can refer to the receipt and they can say, oh, this is who stopped me and this is why they stopped me.
So a couple things. The next hearing is going to be on June 17th. And if you all haven't done so already, please sign up to receive ACLU of Arizona action alerts. If you go to our website, which is acluaz.org, you can sign up for action alerts, which is where we send, it's our email alerts, and we will send you information about the upcoming ACLU hearings.
Yeah, and let me just say
Ma'am,
that the ACLU has been a great community ally, and this is, you know, I have not been asked to do this, but I just want to say that without the ACLU, we would not have gone as far as we did in stopping, you know, pushing back Arpaio and stopping him dead in his tracks, because Arpaio is no longer the Arpaio that used to be. You know, the guy that used to pound his chest and say, you know, he was, even a lot of his rhetoric and his language on the radio, on TV, and everything has changed. But my ask to the community is, you know, this is a nonprofit organization and they rely on donations. So if you also, you know, if you have any influence with, you know, or if you'd like to make a donation, I advise you to do so, because without them, you know, they also need to survive. And thank you for all of your work, ACLU. And again, I can't thank you enough, knowing that, you know, I would not have enough money in the world to pay for all of the legal services. So thank you so much.
Thank you.
Before we leave, I quickly want to let everyone know about the next monitors meeting, which is to take place in July, July 21st. July 21st. The location is still being determined, but please mark your calendar for July 21st. And once we know that location, we will definitely let everyone know.
And just to continue just some dates, the next hearing is June 17th, Friday at 1:30 p.m. It's possible the judge will make clear what his decisions are on the remedies, and including the real possibility of referral for potential criminal charges, which would be interesting timing because the next day the sheriff is appearing at a political event for a presidential candidate, we're told, in Arizona.
So that'll be 1:30 June 17th in Murray Snow's courtroom, which is it's on 401 West Washington in the federal court building there, the big greenhouse. Yeah. But thank you all for coming. We really appreciate it, and we appreciate the support.
El que no crea que haga la prueba.